Good afternoon. I want to first thank you for joining us for another episode of our Testimonial Tuesday. I am attorney Robert Broadie of Carolina Legal Solutions. Today's question comes from a young man by the name of David, and his question goes as follows. If someone harmed or killed a person in self-defense of another individual, will that person who harmed or killed be charged as a criminal? Or will their act be overlooked since it was in self-defense of someone else? Well, David, thank you for posting that question, and it is a very, very interesting question. It's a very good question. In the wake of the Trayvon Martin trial several months ago, almost a year ago, the cause of action as to what constitutes the defense, particularly of oneself, and in this question's case, of someone else, is similar to, in North Carolina, similar to that of Florida's Stand Your Ground. And so in North Carolina, the same actions that you can take upon yourself to defend yourself also extends to you in the defense of someone else. Now, in particularly, the North Carolina General Statute, particularly 14-51.3, is our version of the Stand Your Ground law. And what that law says is that a person is justified in the use of deadly force and does not have the duty to retreat in any place he or she has the lawful right to be if either of the following circumstances apply. 1, he or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another. Now, the key word in that statute is reasonable belief. So if a person is in a place that they're reasonably or they have a right to be, and they have a reasonable belief that someone is putting themselves or someone else in imminent fear of death or bodily harm, then the statute applies and allows for the use of deadly force. Now, that is very difficult for a lot of people to understand because you don't know what the definition of reasonable is. And when you have cases that occur and someone asserts that type of defense, those are really, really the elements that are actually tried. When there's a trial, those are the fundamental things that the jury sometimes have to determine as to whether those actions or the belief as one has in his mind are reasonable for them to take the said action. So the statute allows for an individual to use deadly force if they're in a place that they have a lawful right to be and they reasonably fear a threat of imminent bodily harm or imminent death is being brought upon them. Additionally, the statute spells out that under the circumstances permitted in the statute, generally you are in your home, workplace, or car, and in fear for your life or the life of someone else. So then the statute defines a little bit broader, a little bit narrower, the places in which a person can be to give rise to a place where they're lawful. And it says that if that is occurring in those particular places, there is a presumption that the person is in a place that they're lawful have a right to be. And if they're there and such a threat is brought upon them, they have a right to use deadly force to defend themselves. Now, the statute also spells out some exceptions to that rule. And one of the exceptions is law enforcement, as well as bondsmen in this particular statute. So the statute does not allow for you to be inside your house and shoot a police officer and say, well, I had a reasonable fear that that police officer was going to bring an imminent fear of bodily harm or death or severe injury upon myself. So I used deadly force to protect myself from that threat. So law enforcement and bondsmen, as well as landlords, you can't use such a force against your landlord, because the landlord also has a right to be in that property. So in those circumstances, the statute has carved out some exceptions from where a place such as your home or your workplace can be excluded from our quote-unquote stand your ground version of our self-defense law. So, David, in a nutshell, yes, you do have a right to defend yourself as well as someone else pursuant to our statute if you have a reasonable fear that imminent danger is being brought upon you by someone else, and you are exercising that fear on a reasonable belief that death may occur. So that is the answer to that question. David, we do want to thank you. We want to thank you all for tuning in. We want to encourage you all to support our Testimonial Tuesdays and post your questions on our Facebook page, or visit us at www.carolinelegalsolutions.com and post your questions there. Thank you, and until our next episode, be blessed.